Counselor, what is subject matter jurisdiction?
Senator, subject matter jurisdiction refers to the ability of the courts to entertain matters. Cases that has to be presented in federal court can be moot, have to be ripe, parties have to be standing, and of course, federal courts can only see cases and controversies.
What is substantive due process?
Substantive due process is the process that is used when deciding the constitutionality of a statute, of a matter, distinct from procedural due process, which is based on the process that the courts follow when people are deprived of the due process of law.
Hey everyone, welcome back to Hot News Today. Today, we're diving into a tense Senate Judiciary Committee hearing where Senator John Kennedy questioned 3 federal judicial nominees. Senator Kennedy asked tough constitutional questions. Let's break it down moment by moment. You're not going to want to miss this.
What's the difference between substantive due process and procedural due process?
It's the approach.
And how is the approach different?
It's different because the procedural due process refers to the procedure that it's followed, while the substantive due process technically refers to the way the constitutionality of a statute it's viewed. That's my understanding.
Subject matter jurisdiction and substantive due process. The hearing began with a question for Judge Méndez-Miró. What is subject matter jurisdiction? She explained it determines if a court can hear a case. Next, what is substantive due process? It evaluates the constitutionality of laws. Kennedy wanted more clarity but let it go, for now. Plenary versus enumerated powers, a constitutional showdown. Kennedy asked Judge Antongiorgi-Jordán, can Congress legislate in any area unless the Constitution prohibits it? The judge referenced the 10th Amendment saying Congress has some discretion beyond what's enumerated. Kennedy pressed, so you believe Congress has plenary power instead of enumerated powers? I don't think that's right, Judge. Kennedy concluded flatly.
Judge, the middle judge, I'll call you. Can the United States Congress do anything, legislate in any area that the Constitution doesn't prohibit?
Thank you for your question, Senator.
You're welcome.
That would be correct. I believe it's under the 10th Amendment. There are certain discretion for Congress to go beyond the list that the Constitution provides in terms of the matters that can be legislated.
So you believe that Congress has plenary power as opposed to enumerated powers?
Well, I think that the Supreme Court has acknowledged that there are some rights and that are not enumerated, and the Constitution recognizes the Congress's ability to...
No, we're not talking about unenumerated rights. I'm talking about the power of Congress to legislate.
Congress indeed has that power as per constitutional acknowledgement, sir.
Okay. So you're telling me Congress can legislate in any area unless someone can point to the Constitution that says it cannot?
My understanding would be that Congress indeed can legislate extensively. It doesn't have to be enumerated exclusively. I think that's a recognition that Constitution acknowledges.
I don't think that's right, Counselor or Judge.
Kennedy asked Judge Vélez-Rivé, what is the Chevron doctrine? She answered, Chevron refers to deference courts give to administrative agencies. Kennedy nodded. But this was a setup. Wasn't it recently questioned in the EPA Supreme Court case? The judge acknowledged it was.
Can you tell me what the Chevron doctrine is?
Yes, the Chevron Doctrine is a Supreme Court case in which the Supreme Court ruled that administrative agencies should be given a deference for the decisions that they make. And that decision was questioned somehow in the recent EPA Supreme Court case.
Okay, that's right. What's the holding in Obergefell, Judge?
For me?
I'm sorry. I'm sorry.
Start here and go back that way.
Okay.
Obergefell is the Supreme Court case that recognized same-sex marriage.
Did it hold that same-sex marriage is legal?
Well, it held that it is a protected constitutional right.
Yeah. See, that's not the way I read Obergefell. What I read Obergefell to say is that so long as the relationship is not incestuous, that you and I have the right to marry whoever we want to. And there's no reason to exclude people of the same sex. That's very different, is it not?
Well, Senator, I granted you what I believe that's the holding for that case. However, if I were to become a district judge and if I were to apply that case, I assure you that I will apply the holding of that case faithfully.
Then came Obergefell v. Hodges, the landmark case legalizing same-sex marriage. Kennedy asked, "What was the holding in Obergefell?" One judge responded, "It established same-sex marriage as a constitutional right." Kennedy had his own interpretation. It said, "You and I have the right to marry whoever we want, unless it's incestuous." The judge promised to apply precedent if confirmed. Kennedy thanked the chairman and ended the exchange. This wasn't just a confirmation hearing, it was a crash course in constitutional law. Senator Kennedy pushed the nominees hard. Some handled it with caution, others with visible uncertainty. Judicial philosophy and command of legal principles matter more than ever. Thanks for watching, and I'll see you in the next one.